Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening. This is a special sort of update episode. I posted a Rogers Brief weekly update yesterday dealing with cases that were in the news this week. But one of the big cases that was in the news over the last few months was the Emergency Act inquiry. The Public Order Emergency Act inquiry from Justice Rouleau released its report today, so I wanted to talk about that. For those that don't watch this report all the time, I'm a Nova Scotia-based lawyer. I was involved in the Desmond inquiry, representing the estate essentially of the late Corporal Lionel Desmond, and then was doing analysis of the mass casualty inquiry in Nova Scotia. So when this Emergency Act inquiry started, I was following it with quite a bit of interest, as much in a way for the procedural elements as for the substantive, but I became quite interested in it, and so I've been doing a little bit of analysis throughout the course of the Emergency Act inquiry, and now that the report has come out, I wanted to just give some thoughts about what's emerged from it. The first, I guess, thing, as I was thinking about this report as it was coming out or about to come out, I thought, well, there's a big risk, if it's not well done and well written, there would be a risk that basically no matter what Justice Rouleau said, that it wouldn't change polarized minds. The people that are convinced one way or the other about what took place, or who was justified in doing what. There's a great deal of polarization. So there was a risk if Justice Rouleau came down too clearly, in a sense, on one side or the other, that there would be some pushback or a lack of legitimacy to the report. I think it was really well done. It was about 2,000 pages, so despite the very tight timeline for an inquiry, this is a year. Inquiries can sometimes take several years just to get anything done, and this was started, completed, report written within a course of a year. So in itself is impressive. 2,000 pages is significant. I haven't read the whole thing. It was just released today at 1 o'clock Atlantic time, so I've read the main parts of the legal argument that Justice Rouleau presented, the legal analysis that he presented. And so the main conclusion, of course, is that he determined that the government met what he called the very high threshold, and to meet the standards of the Act, of the Emergency Act, and that he made that determination with reluctance. So just a note on the language. So by noting that it's a very high threshold, and then saying again that he says that the government met it, but he says that with reluctance, well, that's meant, I think, to add some legitimacy to the conclusions, because Justice Rouleau is projecting to the reading public that this wasn't his natural inclination, I guess, to make these findings, that such an unusual invocation of an unusual piece of legislation was justified. All right. First thing, I guess, from a legal perspective, that Justice Rouleau did use the broader definition that was recommended to him of what might constitute a public order emergency. Now, the definitions in the Emergencies Act refer back to the CSIS Act and the definitions there. And the definitions are the same, but the people involved, the circumstances, everything is different about, it's not CSIS determining whether, a foreign government through their, nefarious spying or whatever is a threat to Canada, but rather it's a broader definition made by decisions made by Cabinet and by the Prime Minister. So though the definition is the same, the context is very different. And so not the narrower definition, people will remember, during the proceedings of the inquiry, we found out that the director of CSIS had advised the government that the situation didn't seem to meet their definition of a public order emergency, but the government was able to and entitled to consider much broader aspects of the situation. So, and Justice Rouleau also said that the Act should be clarified on that point, so that confusion about how the definition is characterized shouldn't persist into the future, that the future government, and he's given the government a year to report back on how they have implemented or what they think of his recommendations. So that's one recommendation I'm fairly certain the government will act on, is just to clarify that those definitions are a standalone entity within the Emergencies Act and not dependent upon some determination by CSIS. All right, so the other thing that Justice Rouleau clarified or made clear, I guess, is that you look at this situation from the perspective of the Prime Minister and Cabinet. They're not expected to be omnipotent, to know everything that's going on. They're expected to make decisions based on the information that they receive, which makes sense but is worth stating. So if you think of it as if you think of it in sports terms like instant replay, it's not the, New York or Toronto determining whether the referee made the right call. It's determining whether the referee made the right call considering what he could see and the angle where he or she was standing. So it's not deciding whether it was the correct thing to do in a broadest sense, but whether, given what the government knew, given what the Prime Minister and the Cabinet knew, that they made the right decision or a reasonable decision under the circumstances. And so Justice Rouleau says that they have met that threshold. Now, he had a question about his own mandate, in a sense that the mandate of the Commission, the Act has never before been invoked. And so while Justice Rouleau said, I'm not here to determine the lawfulness of the decision, he said that is for the federal courts to decide. In a sense, he was making the same determination, determining whether invoking the Emergencies Act was appropriate. So, it's basically the same thing, except in a sense that his determinations in this report would not be binding on a federal court in the future that was making a determination on the lawfulness of the government invoking the Emergencies Act under future circumstances. But he did feel, because it was the first time that the Act had been invoked and the first time there's been such a report as his, that he must consider the Act's requirements, go through the legislation and talk about what the threshold might be and all of those things. So it's a very good report, and I think for future governments that think about invoking the Act, this report would be a good resource, of course, to use to figure out what steps they should be taking and what things they should be thinking about when they're determining whether to invoke the Act. So the another couple of important features of the report is, he says, yes, it was reasonable to do under the high threshold at the time the decision was made, but it wasn't inevitable that it would become an emergency, that there were two sorts of failings that led to the situation becoming an emergency. One was police failings, that there was a series of police failings by the Ottawa Police and Ontario Provincial Police, the RCMP, there was mostly the Ottawa Police, but other police forces, there were police failings. And then there were failings to rise above politics. Failures of federalism, cooperation of municipal, provincial, and federal governments. He points out specifically the Doug Ford Ontario government is one that was seemed to be reluctant, more than reluctant, to get involved at different stages. Didn't testify. He mentions that would have been very helpful if the Premier and other ministers and officials within the Ontario government had agreed to testify rather than invoking parliamentary privilege as they did to avoid testifying. So Justice Rouleau sees that as a failing of the Ontario provincial government. So the four things he had to consider to determine whether this was appropriate. There were four factors, I guess. One was the situation urgent and critical in such that it endangered lives, health, and safety? Well, he determined that yes, it did. The second one was there a political, religious, or ideological objective behind it with a threat of serious violence? Now, this is the area where the CSIS definition and the Emergencies Act definition diverged on the question of, serious violence. The CSIS definition would basically require that it rise to the level of, you're going to lose your national government, is in danger of a foreign influence or some other entity taking over. The Emergencies Act definition doesn't take it to quite that level. Justice Rouleau was very conflicted, nevertheless, about whether the events led to a state of affairs where this definition was was reached, this threshold was passed. But he says, yes, there was, and there certainly were political elements to the protests and ideological elements to it. Not religious, but politicians were named and threatened. There was ideological reasons behind the protests. Whether it was to do with the COVID pandemic mandates or other reasons. The third thing was the situation had to be beyond the capacity or the authority of a province to deal with. And in that case, he looked at it and said, well, the issues are national in scope. There were protests in British Columbia, Alberta, Nova Scotia, Manitoba, in addition to Ontario. And so the issue was really national, and that there were, beyond the capacity of one single province to deal with. And the last one was, could it be effectively dealt with through existing law? And Justice Rouleau really leaned on the word effectively here. And so, as I said before in my other pieces earlier on this, you can't just think of these things in a vacuum. You have to consider the actual capacity of police forces, political organizations, governments to deal with these things. You can't just think of, in an idealized world where we have, perfect leadership and efficient operation of, police forces, could this be solved? Well, no, you have to think about things like, could the police have gone in and arrested people for assault? Yes. However, sometimes when the police went into crowds, they were swarmed and they were in danger, and thus, practically speaking, they couldn't do this. They couldn't effectively deal with it through existing law. And so Justice Rouleau found that that was the case, that it was beyond the capacity of forces to effectively deal with it through existing law. So it passes all the threshold questions. He said there was credible threats, difficult for Ottawa residents, but also threats throughout other parts of the country. And so there was a reason to invoke the Act. Now, after invoking the Act, then the Justice Rouleau looked at what was done to, in the course of, the new authority. He said, well, there were some good things, such as compelling tow trucks and freezing assets. Those were good things that were useful, but there was no delisting mechanism. So if people left the area, then their name, he felt, should be taken off any list of people whose assets could or should be seized. So that wasn't done, he thought, effectively. And these exclusion zones where trucks couldn't park or people couldn't be, he said those weren't clearly defined, and so there was some danger of an overbroad application of those new laws that came in. And by the way, just on a recent thing, because it was just yesterday, geez, it seems like a long ago time now, that Brenda Lucki resigned, the commissioner of the RCMP. And one of the reasons, or one of the thoughts behind her resignation, which was a little early, a month early or 2 months early, was that this Emergencies Act inquiry report was going to be very critical of her. It really wasn't. There was an incident. So Brenda Lucki and the RCMP felt that there were policing options that hadn't been explored, and at the late date on the 13th, and the Emergency Act was invoked on February 14th. On the 13th, she was at a cabinet meeting and had this feeling that there was a plan in place, or a plan available that could have used existing resources to deal with the situation. She didn't speak up at the cabinet meeting, and there was some thought, some suggestion that that was going to be criticized by Justice Rouleau. Actually, he mentioned it, but he wasn't critical of it. He said, well, yeah, maybe she should have spoke up. But at that stage, that late stage with the plan, even if there was a plan, it was going to be a fresh plan with lots of doubts still, injected into it just by the fact of its late arrival, a late development. And so that wouldn't have made a difference probably to the determination of Cabinet, wouldn't have made a difference in his determinations either. So we give Brenda Lucki a little bit of an easy ride there for her reluctance or lack of initiative to speak up under those circumstances. So interesting stuff there. So the recommendations I've talked about, one is a change of the legislation to ensure that there's no confusion between the CSIS Act and the Emergencies Act. He also recommended that more time be given for Emergencies Act inquiries to take place. This was a year. It was a tight time frame for an emergency, for any kind of inquiry. The Desmond inquiry was 5 years. The Mass Casualty Commission, 2020, we're into 2023, so that's over 2 years, and so things take some time to do, and if you want them done right, they have to be you have to take some time. Now, Justice Rouleau did a good job with this report, seemed to work very hard to get it done, and so kudos to him for that. Lots for everybody to chew on here. Certainly the government will be pleased in a sense that they were cleared, that they were told, it was determined that they made the appropriate call, but it was only the appropriate call because of the many failings leading up to the invocation of the act. And so there's lots of blame to go around there, from governments that weren't able to cooperate, or planning that wasn't done properly at an early stage, and obviously the policing situation in Ottawa and other places, the Windsor border, Coutts border, that just weren't that organized in advance and were overwhelmed by the situation that they should have been able to predict. So there's lots of criticism to go around. Some, certainly not an exoneration for the government, but they'll be able to say, I'm sure they will claim, that they were cleared as a result of the inquiry. That's not the case. Justice Rouleau, like he said, was very reluctant to say that this crossed the threshold. Doesn't want to encourage future use of this act. Seemed to want to discourage that, and so we'll see how this develops over the next little while. Anyway, that was my analysis of the report that came out today. I'll talk a little more about this next week as I read through in more detail of the report. Those are some of the legal highlights, and we'll come back to it next week. So in the meantime, so thanks for watching that. If you enjoy this content, like and subscribe, share it with others, and we'll grow the legal analysis online community. Okay, thanks again for watching, thanks for listening, and we'll see you next time.